All right, Davis, you are good to go.
All right. Well, welcome everyone to the subcommittee for proposed 2025 FEO3. Members of the committee are advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. And so, with that, obviously, I think Brian or Brett and Brian circulated the new proposed order or opinion that came. I think it was sent to us last week
Mhm.
or the week before that. And so I would just maybe open the floor to Brian to kind of go over what he did, and then we can kind of take it step by step from there.
Yeah, I think I'll probably be the easiest. So, Happy New Year, everyone. Good to see y'all. So the last time that we met, you might remember this proposed 2025 FEO3 dealing with the potential to have language that allows a fee increase and kind of a periodic or regular fee increase. We heard from some of the folks that submitted comment to the published opinion, and namely those folks were from larger firms that have different clients, whether they are incredibly sophisticated clients who have requested this particular provision, saying, hey, we want to put in the fee agreement kind of some parameters for when you can adjust your fee, when the fee adjustment should occur, things of that nature. Or they are just, regular users, frequent users of legal services, and they have truly no problem here with this type of language that allows a fee agreement. And I think that really generated a lot of conversation about what we were getting into with this opinion, and the scenario that was provided by the grievance committee was one where the power dynamic, if you want to call it that, was maybe more in favor of the lawyer, where you've got a lawyer that is offering a fee agreement that has some vague language. I will check my fees on a periodic basis, and I'll adjust them, and I'll let you know when those changes go into effect. And that client basically just has to accept it if they want to have that representation. Maybe that client is somebody who very infrequently uses legal services. Maybe this is the first time they're using a lawyer, retaining a lawyer. Maybe this is just a very tough situation, and they're just kind of just saying like, okay, I don't even know how to respond to that, I'll just agree with it. And we recognize that there are different clients in different scenarios, different situations, different sort of give and take that occurs in creating that attorney-client relationship. And so we wanted to make some adjustments to the opinion to reflect just that. And that was a lot of the comment that we received, and particularly I remember hearing from some of the folks that offered comment about having long-term relationships with, say, large corporate entities that they've got a fee agreement in place, and it's been that way for the past 5, 10, 15 years, operating under a fee agreement, and really the notice that is referenced in the opinion becomes very impractical when you are dealing with a larger firm that's addressing one of these larger clients, such that maybe you have 20 lawyers in a particular law firm working for a single client, and anytime their fees go up, the opinion would require sending notice to the person, to the client. And while that is more practical on kind of that individual basis that's addressed in the original inquiry, it becomes impractical in other scenarios. And so that's what I tried to do. I tried to capture what the subcommittee was discussing, and I think the direction the subcommittee wanted to go to kind of I don't want to say carve out an exception, but just interpret the rules in accordance with the client. The client being one of the factors of determining what is appropriate for fee adjustments, what's understood, consent, understanding of different terms, things of that nature. So that's what you have here. So I'm going to go ahead and share my screen just so we're all on the same page. And you all see basically the opinion was the same for the first five opinions or five inquiries. But then we get into I added inquiries number 6 and 7. So Inquiry number 6 basically addresses that first question of, all right, so the client has asked for this provision to be in here. The client has directed lawyer, I want to know what I'm dealing with, and I expect you're going to increase the fees, or it's reasonable to expect some type of fee increase. So I'm going to go ahead and ask you, lawyer, to include a provision, maybe even insist upon the inclusion of some type of language that offers the lawyer, and really maybe even for the convenience of the client, offers the client the kind of ability to predict and anticipate what will happen over the course of our long-term attorney-client relationship. And it asks that question basically, if the client is the one that requests or insists upon the inclusion of that non-specific language, such as was described in the first inquiry, does that change the analysis? The answer was yes. That essentially the analysis in those prior opinions is specific to where the lawyer is requesting or requiring the client to agree to that fee increase language as a condition of I see it says representations. Let me eliminate that plural. Representation. But and it also kind of, those first inquiries presumes that that the client is I guess we would say an infrequent or unsophisticated user of legal services, but that under these different facts, client has requested it, and that request kind of indicates the client's understanding, consent, and desire for that arrangement. And kind of reiterating that, as we discussed in opinion number 3, the reasonableness of an amended fee agreement with a client depends upon the context, the circumstances of that representation and the attorney-client relationship. And here, the fact that the client is requesting that is one of those factors to be considered. So the lawyer may include that non-specific language, and any notice that's required, of course, can be in accordance with the requested language by the client if the lawyer is agreeing to it, of course. But of course, the ultimate principle that any sort of adjustment to a fee would need to comply with Rule 1.5, and that it cannot be clearly excessive. So that was inquiry and opinion number 6. I'm going to describe 7 as well, and then we can kind of go back and see what we're thinking about that. 7 is the other additional inquiry, where we're dealing with kind of I termed it as a corporate client, that you have, as opposed to the inquiry number 6, I have it as just client. Whether it's a corporate client or whether it's an individual, I started kind of getting into merging these two and realized that they really are two separate things, because you might have an individual client who uses legal services all the time, or maybe maybe this is the first time they're hiring a lawyer and they say, I want this term in there. Just the bottom line, when it originates from the client, it kind of changes. That's a different consideration. Inquiry number 7 really deals with that corporate client that's a frequent user of legal services. Maybe there's a prior attorney-client relationship, or that has existed in years past between lawyer and this corporate client. But that essentially you're dealing with, as described in the opinion, a sophisticated consumer and frequent consumer of legal services. And so corporate client basically gets offered this fee agreement, kind of still comes from the lawyer, that there's some sort of language in there about fee increases and so forth. And because the corporate client agrees to it, is that permissible? Whereas before we said not exactly, you need to have some sort of notice under the rules and all that, but here we're saying the corporate client, being the frequent user of legal services, the sophisticated consumer of legal services, and again, ultimately recognizing that power dynamic, for lack of a better term, is different here when you're dealing with that large entity client. That ultimately that does again change the analysis in setting out that yes, you can have that type of language, the non-specific fee adjustment or fee amendment language, when you're dealing with that sophisticated consumer of legal services. Same thing with regards to any sort of notice, and really I specifically put in here that that imposing the same notice requirements on the corporate client as the unsophisticated consumer or infrequent user of legal services would be impractical. and maybe even a hindrance to the attorney-client relationship, given the law firm's general relationship and function and so forth. And so it's opinions number 6 and 7 essentially are are here to kind of create a different set of facts to say that not all clients are the same, that but really emphasizing that whether the client is requesting the language or whether the client themselves is a sophisticated user of legal services, frequent consumer of legal services, that really kind of creates a different context. And I guess I will also note that in opinion number 7, I tried to flush that out a bit more because this isn't just coming from our conversation. We actually have multiple spots in our rules and ethics opinions where we recognize sophistication of the client is a factor in determining exactly what a lawyer's professional responsibility is, which makes sense. One of the, I think it's the very first line of the scope section that says the rules of professional conduct are rules of reason. And it's reasonable to take into consideration the sophistication of the client. We see that with, 7.3 solicitation. Direct solicitation is permitted. It's otherwise prohibited, but direct solicitation is permitted when the person who's being solicited is a routine user of legal services, at least of the type that's being offered. There's a recognition of sophistication of the client in Rule 5.7, dealing with law-related services, noting that you might need a bit more explanation to somebody who is not a sophisticated user of legal services, to kind of distinguish between the lawyer services versus the law-related services. And again, in 2009 FEO 3, there's another reference to that. So this isn't. I say that just to say that we're referencing this, but I think this is very well grounded in what we have previously dealt with. It was kind of just like a conversation before, kind of an idea, and I wanted to make sure that everyone was aware that this is actually, it's more than an idea. This is something that we have recognized historically in the rules of professional conduct and in our ethics opinions. So that's opinions 6 and 7. I'm really resisting, as I say opinion 6 and 7, to like revert to talking with my kid and saying 6, 7, because that's a thing that everybody does. I don't know if anybody's got preteens now, but there it is. So we are here with these amendments. I would love to get your feedback though, as to whether or not you think this captures what you all wanted to do. Do you think this addresses the concerns articulated by those that submitted comment? Any changes, anything like that? So that's my summary, Davis.
Thank you, Brian, and I appreciate all the work you've done on that. I would just open the floor to any of the subcommittee members to give their comments. I think I saw Elizabeth on here. Maybe is she still here? Yes, she is here. She is here. Okay, she was on the second line of attendees on my grid here, but I didn't know maybe if you wanted to start offering since you were the subcommittee member in a larger firm that this might affect.
I'm happy to start. Yeah, and I'll admit too, I wasn't originally a member. I think I had some questions about it prior to that caused me to become a member. So I want to admit first, I didn't read the whole thing. I got it on the second, and so I want to do that. But having skimmed it and listening to your thoughtful remarks, Brian, I think it's very helpful, and I just want to thank all of you for taking the firms, including my comments, into account and drafting it. I think particularly the response to 7 is helpful, because whether or not the client wrote the terms, which I remarked is sometimes the case, the ongoing nature of the relationship, I think, gives us a pattern of practice. I've been this week submitting rates into a billing system for some of our clients who prefer to handle it that way. And I'd like to be able to take their payment of the next bill and, consistent with the terms I uploaded or the fees I uploaded, as a sign of assent like we've done for years. So I think that description helps us to feel better that that's appropriate. So thank you. I don't have any questions or concerns to flag for the group at this point.
Anyone else have any thoughts on it?
I'll weigh in. I think I think you did capture what we talked about from the last subcommittee meeting. Um, I think it really well. I think one of the ideas about the provision for periodic increases in unspecified amounts coming from the client probably is a valid consideration, but I think more importantly, it really comes down to either the course of dealing with the client, if they're used to having that kind of arrangement, number one, or just the overall sophistication of the client. Because I mean, I think 7 probably addresses the situation I have with a lot of my local government clients. I mean, technically, I guess they are a corporate entity, but they're not a commercial corporate entity, but they're pretty sophisticated users of legal services. And, we're one of many law firms used by a number of our local government clients, and so they know what they're getting into with these kinds of agreements. So I do think that the sophistication of the client is probably as much of a consideration as anything. So I'm good with the additional opinions. I do have a technical issue or a language issue that's, I think, included in both proposed opinions 6 and 7, and it's the reference to or the use of the phrase the non-specific language in a fee agreement. I think what we're talking about is periodic increases in unspecified amounts.
Yes.
Not non-specific language in general, but it's about an increase in an unspecified amount. I think that makes it read better, but I assume that was the intent of that, and I think
That was John. I think that's I mean, that non-specific language. It's something when you're writing these things, you're like, I don't know how else I'm describing it. I think
Yep.
people understand it, but I don't know if it's really coming through. That's exactly what I was trying to get at. So it's the periodic increase. I'm gonna just make a little comment to that effect and flush out that language. But basically to say it's a periodic increase in an unspecified amount or something like that.
Yeah.
So we'll just
Yeah.
I'll just thank you for that, John.
yeah. But those were my thoughts.
Does everybody else agree with that? I guess that was my intent with the non-specific language. I'm kind of presuming everybody would be good with that slight adjustment.
Yes.
I'm fine with it for what it's worth. When the clients draft terms, they often say nothing about this,
Hmm.
just for interest. uh,
Okay.
I was inclined to think if that was the case, then the response to number 7 would be helpful in terms of the practice and their expectations.
Can I, John and Elizabeth, you both mentioned the I think you said like the relationship with the client, kind of the typical practice experience with the client. And I feel like I could potentially highlight that a bit more in opinion 7. Um, did you, and I know it's highlighted in other parts. I think opinion 3 talks about, the prior relationship with the client that could be a consideration in determining what is and is not appropriate or reasonable. Would you feel better about opinion 7 if that was highlighted a bit more? That it's not so much the sophistication of the client, but it's also the expectation with that client based upon, I don't know, maybe it's their prior experience, or maybe it's just kind of the I don't know, want to say, I don't know if it's like the norms of dealing with those types of clients.
Well, I think you've got that in 7 when you reference the history of interaction between the client and the lawyer.
Right. Okay.
So I think that
That's right.
addresses it,
Okay.
or at
Yeah,
least
it
it's
didn't
included
strike me,
within that.
Brian, reading it for the first time as sort of lacking in that regard. I will
Okay.
agree. Not all the clients I'm referencing land on me as sophisticated, but they do have a habit of dealing with lawyers. Maybe that's why they don't seem sophisticated to me.
Okay. No, that's great.
Brian, I was just going to throw this out there. I know, and I think it's a good use of our time to focus on 6 and 7 because that'll tackle a big item that was a conversation for our last meeting. Were there any other changes to 1 through 5 that you made?
I made no other changes to 1 through
Okay.
5.
Yeah, yeah.
I'm
Go ahead.
sorry. I'm sorry, I didn't mean to interrupt. I had a thought on item number 4. I mean, I didn't, like you said, I didn't notice any changes, but it came back to me that as I was looking back over this, that I'm a little concerned about the way in inquiry 4 we refer to 3% as the example of a automatic increase.
That's right.
And I feel, again, I think we got a little pushback, but not a whole lot from some of the larger firms about. I got a call from one of my friends at a big firm whose firm did weigh in on this formally, but he called and said, "You mean to tell me we can't increase fees by more than 3%?"
Yeah.
No, that's an example, But anyway, I think that's something that could still, once this is published again, it could create some feedback. I would rather just make it clear that we're talking about a specified percentage. Or even a specified amount, and then using whatever we use as just being purely an example, so that no one thinks we're prescribing what a reasonable increase would be.
Right.
Yep.
So I do remember that.
I mean,
Go
I, can I speak
Yes, please.
to that? Okay. So, why can't we just say to us, instead of saying to be no greater than 3%, why can't we just say to be no greater than a certain percentage?
Mm-hmm.
And I just made that change actually in the
Yeah.
document on your screen. I said a no greater than a set percentage, but we can go a specified percentage. But yeah, I think that's right. I remember hearing that feedback as well, and the 3%, although intended as an example.
Yeah.
Sorry, Brian. So
Yeah.
let's say the set percentage was, a number, obviously, but does it have to remain reasonable in the circumstances to actually meet the ethics requirements? Or can we put in any percentage and then it's fine because it's in the fee agreement?
I think that's where we have this language, provided the increase in rate is not clearly excessive. That would be the test, the
Mhm.
increase. And I think that was the thing. The problem with percentages is, and I think that where this is a good change, because it really does need to focus on clearly excessive. Somebody that increases their rate from $150 to $200 an hour, just for example, is increasing their rate by 33%, but it's $50 an hour.
So I wonder what the group would think about the answer then being yes, provided the increase is not clearly excessive.
Yeah.
Just to emphasize, if we're opening it up in that way, that you do have to put some thought still behind. I get that says that later. I just personally would feel more comfortable if emphasized.
I think it would be. I think actually, shouldn't it be yes, provided the resulting rate is not clearly excessive?
Yes.
Yeah, good point.
Yeah.
That's right. Oops.
Yeah, there we go.
So, if we're done with 4, I had some thoughts on 1 and 2.
Okay.
Is that okay? Can we move on from 4? Or we?
Absolutely. Unless anybody's got any comments on 4. I think that was the only thing I had on my list that people brought up that I wanted to make sure we tackled as well.
So I'll start from the end with opinion number 2. I'm uncomfortable with the way that it reads as a domestic lawyer. Sometimes our cases go on for years, and the rate that we've charged initially may increase over time. I just by way of example, I'm in a small firm. We send out notice 60 days in advance of a rate increase that's going to begin January of every year. And we've not really had any complaints, but they're not excessive. So I think that the way this reads is can make lawyers feel stuck and can make us feel like maybe we need to have a termination date in every contract so that we can withdraw at the end of the year, and unless we can renegotiate something. I'm afraid that it may have some chilling effect on services that is unintended, because we're worried about whether or not we can get out of a case if we have a client that's not paying. And so with regard to number 2, it's can a lawyer withdraw from representing a client based on client's refusal to pay the increased hourly rate? I don't think that the answer should be not immediately. I think that the answer should be it depends on whether or not the client has an imminent issue to be addressed, right? So if we're giving 60 days notice and we hear an objection, yeah, I'm not going to pay that fee or I'm not going to pay that bill, then the client has 60 days or potentially more to find new representation if there's going to be an unresolved fee dispute. But if we're giving that notice a week before there is a return hearing for domestic violence or a custody hearing or something along those lines, then the client is stuck in a really terrible position. So I think that it depends is better than not immediately. Or just to say it depends, a lawyer can't immediately withdraw if the client has an imminent issue that needs to be addressed and would otherwise be, prejudiced, because you don't want the client stuck in a bad position, but you also don't want a client who thinks that they're entitled to representation forever because they paid an initial deposit and it's run out. So, I've seen a lot of lawyers in family law will go to flat fees instead and say, hey, you need to pay me $10,000 to take these depositions, or you need to pay me $20,000 if you want me to handle your custody case that's coming up. Personally, I don't feel like, this is maybe not the right thing to say, but I find that a lot of the lawyers that file or that charge flat fees do minimum work for maximum dollar. And I find that as the hourly billing lawyer, I'm having to correct a lot of documents and make things a little more detail oriented and precise. And now that's not true across the board of everyone who charges a flat fee. I'm just saying I think that it can sometimes impact the quality of the work. So I personally don't want to switch to a flat fee, but I think this language like this, if it doesn't allow for some withdrawal because of a fee dispute, then I think that that's ultimately going to have a negative impact. So I also don't I disagree that it feels like there's a fee negotiation or renegotiation taking place every time you're raising your fee. If this initial fee agreement in Exhibit 1 provided for the rates to go up, and I don't have a problem with that if the representation exceeds a year. Or if it's done every January or whatever, I think the notice is important. And I wouldn't have just stuck it on someone's bill and said they had to live with it, right? I do think that there's a notice requirement, at least for individuals. But I think that this reads that if you want to raise your rates, you're risking a bar complaint every time you do, or being stuck with with a client, and it doesn't really define how long you will have to continue to represent that client potentially without getting paid. So the last sentence above inquiry number 3, I had changed that a little bit to say, notably, lawyer retains the ability to withdraw for reasons other than and this isn't magical language, it can be worded better, other than the last minute disagreement of an increase in the fees. Because I think that otherwise, this may be read to say you can't withdraw just over a disagreement in fees. And I think that we have disagreements in fees all the time. And when a client's balance is getting too high and they're not making any effort to pay their bill, I want to be able to get out. That's not indentured servitude, right? So, so I had also, I also wondered if maybe we should, under opinion 2, if we deleted not immediately and deleted lawyer may not abandon that, see opinion 1, and deleted the word although and just started with lawyer. Lawyer may withdraw from the representation based on client's refusal to pay the increased hourly rate if client receives adequate notice and the increased fee is not clearly excessive. Because I think it's the adequate notice that we're really most concerned with. And then, when you saw, there's a quote here for the Virginia ethics opinion: changes to existing fee agreements are permitted so long as they reflect a fairly negotiated agreement by the client and the lawyer to modify or supplant, blah, blah, blah. Fair is, like, we call it the F word in family law, just because everybody always wants what's fair, and that has an ambiguous opinion, or definition. So I put voluntarily negotiated agreement, or I don't know, or we could just, like, I don't think that that's necessary either, or maybe put, and instead of quoting that Virginia ethics opinion, maybe just move the second sentence: lawyer may not abandon or threaten to abandon the client to cut the attorney's losses or to coerce an additional or higher fee. That may be the, a good sentence to put second after lawyer may withdraw, and then not have the Virginia ethics opinion cited. Just because I don't think it's a renegotiation. So,
Well, Laura, let me jump in. So I think it certainly was not, I think, the intent to say or to convey lawyer can't withdraw for over a disagreement about fees. I think that was the point of this sentence here that I've kind of highlighted. Although lawyer may withdraw from the representation, and kind of trying to say, like, you can withdraw if you receive that adequate notice and the increase is not clearly excessive. The question was the immediacy of the withdrawal. And I think that's where, like, the terms negotiating and just kind of all this stuff is really stemming from that language in Rule 1.5 that is unique to North Carolina and a couple other jurisdictions. Um, it's not in the model rules, but this notion that a lawyer cannot abandon or threaten to abandon to coerce an additional or higher fee. And I think that, like, I know that was part where we were trying to thread the needle of when is a lawyer trying to do something that's coercive, because that does happen, and that's what Grievance gets reports of. Suddenly there's an increase in the fee, and it's just so happens they've got a pretty big hearing coming up, and now they need to get paid more money or whatever, and that can have that coercive effect. And I think our language in our rules is supposed to, or is meant to protect against that. So clients aren't put in that awkward position. But then you have the very legitimate scenario where you have client who's acting inappropriately by not paying, and they're pushing the lawyer to a spot where, like you said, maybe it's been going on for 2 years. The world has gotten more expensive. Lawyers' fees have reasonably increased, and the increase is not clearly excessive, but the client's just refusing to pay it. At some point, is there some sort of disagreement where a lawyer can withdraw? And I think the rules do permit that to occur, but we have that language. I think that's to me that's the, I guess, quote unquote problem, or maybe it's just a little bit too drafted in a client's favor. This notion of you can't withdraw if it's going to have a coercive effect. So
because I think that we see people withdrawing because it takes forever to get on the court calendars here. Sometimes you can't get the court calendar date to withdraw until the actual date of the hearing. And it's not that there hasn't been some discussion ahead of time, just the client isn't consenting. And then there's this hearing date. Well, they've had an opportunity to get new counsel and maybe just haven't. So I think instead of saying not immediately, I think maybe we need to say it depends on the circumstances. And
yeah,
whether
I think you're right, Lori. I'm fine with it. Depends. I think the other, like this one, I remember this language, this last sentence. I think we added it because from like a prior committee meeting where it didn't exist before, but we wanted to be clear that, listen, lawyer, you still have like the ability to withdraw under all the other provisions in 116B, as long as it's not prejudicial to the client, all that kind of stuff. It's just because you're having a potential fee issue doesn't mean that there may be some other grounds that legitimately permit withdrawal. And so I don't think that last sentence is necessary. If it's potentially sending kind of a different message and saying, like, maybe conveying that, hey, you cannot withdraw over a disagreement with fees. That was not the intent. If that's what it's communicating, then I would recommend that we take it out, because I don't think it's material to the analysis.
So otherwise, maybe just stop it at notably lawyer retains the ability to withdraw for other reasons, period. Or as provided in Rule 1.16B.
Right.
And delete the other than the disagreement over fees.
Yeah.
Because I think that language is too broad, other than the disagreement over fees, because it may have been an ongoing disagreement.
Right.
And I think I'm not so sure that 1.16 doesn't also include a disagreement over fees, since it includes that the client fails to fulfill an obligation to the lawyer regarding the lawyer's services, et cetera, et cetera. So,
yes.
Yeah.
I mean, I understand Lori's concern. I think that's a valid concern. My thinking is that from a timing standpoint, if that's what we're trying to address with opinion 2 here, I can see why it said not immediately, but maybe, I mean, the real question is whether you can withdraw for this reason or not. And I think the answer is you can, but there's a process you got to go through, or there's some steps that you have to take, which is why it says not immediately. So maybe what if it, instead of saying it depends, what if we said yes, but only after complying with, and then recite what the requirements are or make reference to the requirements in the rule about terminating representation, because it's already covered there. Because that's what I think you would need to go through in order to be able to do that in that situation.
Yeah,
Yeah,
yeah, I could be right,
I'd
and
like
I
that
think
even more. I just don't want to limit client. Yeah, yeah.
yeah, yeah, that's the, and I think I could see something like this if we have the it depends, if it not maybe not immediately,
Or
maybe it's
yes,
just
so
kind of
long
like
as it is in
yes.
compliance. I think that's great.
Yeah.
And I think there would need to be kind of a provided it's in compliance with Rule 116. And I guess this is the part of kind of the timing and what we're talking about here, because we do the the balance here. We've got competing rules, at
Mhm.
least just read purely on their face. The notion of you didn't comply, you client didn't comply with a term of this agreement that we have, and that is a reason to withdraw. And it is, lawyers are not required, like you said, Lori, to be indentured servants, to be to not be able to get paid for their services. There's no requirement. There's no vow of poverty or something like that. But then we have that language that we compare with Rule 1.5, and at some point we may need to amend this comment, quite frankly. But the comment about, you know, you can try to renegotiate the fee in light of changed circumstances or other good cause, but you can't abandon or threaten to abandon. And of course, it's to cut the attorney's losses or to coerce an additional or higher fee. And that's where it's like, it's not so much, it's like the comment portrays it in a negative light. And it's not necessarily that the attorney is coercing a higher fee. At least, I guess maybe that would be the thing. If we had clients, if we had members of the public here that have dealt with lawyers, they might say, yes, I was coerced to increase the fee, to pay more money. But I think that the point is that we have this language on its face that kind of portrays an increase in fee, and kind of, I think it can be read to say, well, all right, well, once you've made your deal, then that's the fee, and any sort of increase is something that the client would need to consent to. That you can't just impose it on them and then say, if you're not going to pay this, I'm out. And I know that's what we've seen in some of those other, I think maybe in like the worst case scenarios that Grievance has seen. But trying to compare, I guess, have this notion of, all right, we're not trying to coerce a client to accept the increase, to have to pay under threat of losing all representation, having to start over. It's really kind of we're trying to accommodate and be reasonable with the reality of economics and what is reasonable to charge. And if there's an increase and you refuse to pay this increase, that at some point it needs to be reasonable for a lawyer to say, listen, I can't continue on in this three year long case making, or charging a fee that I don't, it is old. It is out of date. It is something that's not really feasible for me to maintain this practice. And so I think maybe that's what we're talking about, that it's kind of the answer to opinion two sounds like it's, can you withdraw? Yes, provided that you have complied with Rule 1.16. And I guess that's my question to you all is it helpful to say, and so long as the withdrawal is not an attempt to coerce the higher fee. It's like it makes it kind of a question of, it's supposed to be a genuine, this is an increase, I've given you notice, I have to do this for just the practical purpose of running this practice. And I know that is not black and white, because other people will say, I wasn't coercing, I was just dealing with my practice. But I think whether or not somebody is or is not coercive in their attempt is going to be something that is going to be very much dependent upon the circumstances. And if they really find themselves in a grievance situation, the Office of Counsel is having to demonstrate coercion, which I don't know that ever would really come up, but that would be something that I think the circumstances would play out. So what would you think about, yes, provided the withdrawals in compliance with Rule 1.16 and the fee increase or the withdrawal is not an attempt to coerce a higher fee?
I'm good with it.
I feel like you're thinking about it, Lori, and there's something that maybe doesn't sit right with you. That's my gut.
Um, I don't want the client to be able to say it's coercion every time you increase the fee. I
Right.
think the issue is the notice and ability to plan, right? So I think it's whether or not there's some, I think
It's like having the word coercion kind of puts a flag on it of, hey, client, just claim
yeah,
coercion.
every time you raise your fee, oh, she coerced me into paying it. I had no choice. Which I think is sometimes really how clients do feel, but it's not coercion if you have an opportunity to go somewhere else. And so that's what I'm trying to think through in my
Right.
mind. Just because the client may feel that doesn't mean it's actually legitimately true.
I get, Lori raises a good point. I mean, I've never seen this happen that I can recall, but let's say you propose an increase under a fee agreement that says annually we may propose a fee increase and we'll give you advance notice of it. You propose the increase, the client says no, so you move to withdraw and you give them notice and so forth, and then they come back and say, okay, I'll agree.
Mhm.
Can you then say, okay, fine, we'll go forward, or do you need to say, sorry, you said no initially, and I'm not trying to coerce you into agreeing to it, so
Right.
I can't agree to it now. I mean, does it put you in that position? How else do you know whether or not there's been coercion implied?
Yeah, no, I mean, this is, we've got this, I mean, the word coercion is something that it is subject to the interpretation of the person that's using it. We have the
Yeah.
same sort of thing with, in the 7 series, in trying to, talk about your legal services and all this kind of stuff that you can't kind of, engage in methods that imply some sort of coercion in your advertisement and description of legal services that your firm offers. Like the sending the letter saying you need to call me right now or you will suffer incredible consequences, for your traffic ticket. The that sort of stuff. But so I think what I've written in here is, to change this from not immediately to yes, provided, that the withdrawal complies with 1.16, the client received adequate notice of the proposed increase. I think that's what we're getting at.
I think that it's the notice
Yeah.
aspect.
Because the notice triggers the ability for the client. I think that's the thing, that it's not so much, hey, I'm increasing my fee. Well, I don't like that. All right, then I'm withdrawing. That's coercive. That potentially coercive, at least, and I think that could be something that in the interest of the public and interest of clients that shouldn't be just kind of that's going to be an accepted practice. But if it's kind of all right, I'm complying with Rule 116 that it's not prejudicial to my client
Yeah.
to withdraw, and I've given you notice of this increase, and it's not you've had the opportunity. I think the opportunity to respond to the increase kind of removes that question of coercion to me. So perhaps
Right.
that would be the solution.
I think the adequate notice being added to that addresses the issue that I think we're trying to really resolve with this opinion. So, that brings me to opinion 1, or excuse me, to inquiry 1.
Mhm.
Under opinion, in that first paragraph, after no,
Uh-huh.
then rule 1.5 is cited. And then so after that, it says, after the representation begins, a lawyer may attempt to renegotiate a fee agreement.
Mhm.
I don't think that's what's happening. I don't think you're renegotiating a fee agreement. I think that in this particular scenario, there was a fee agreement. What they were doing was increasing the fee. So after the representation begins, a lawyer may increase the fee during the course of representation. I just didn't
Yeah,
may
I see what you're saying,
may have
Lori.
a fee increase instead of saying like may have a fee increase per their agreement. But a lawyer can't abandon the client to cut the losses or coerce a higher fee.
Oh my goodness. Sorry about the back and forth. So I think you're saying it's this section here.
And it's not a renegotiation. You're not having to renegotiate your fee every time you want to raise it. It's after representation begins, a lawyer may increase the the fees charged per the terms of their agreement during the course of representation. And then it says, but a lawyer may not abandon or threaten to abandon to cut losses. And maybe we say in that may increase the fee with adequate notice or something like that.
Yeah, well, and so the language of renegotiating a fee agreement is all from the comment to the rules. So it
Yeah.
wasn't. I want to be clear. It wasn't my language. I'm using what's in there, and I think that's the part that I recognize kind of the description in the rule of renegotiation of a fee. It's like it sounds like it, and I think maybe that's the thing. Maybe that's what when I read the rules, I think it can be, I don't know, it's like it doesn't seem practical to interpret it, but like on its face, I think it says kind of once you've established your fee is your fee, and you can't just go ahead and like any change to that is a renegotiation instead of bringing somebody in, having them retain you, and then you say, actually, I need more. And I think that's what it's trying to protect against. But it doesn't account for reasonable periodic increases when you have a representation that extends over a number of years. So that's where like the language in the rule or in the comment I think is a bit more limiting. And the description of renegotiation, I see what you're saying. I don't know if this is something that this. I mean, I'm curious to the committee here if you all, I don't know, if you all don't like the language in comment 5, is that something that we need to we need to review at some point? But or maybe we just need to clarify, the renegotiation of a fee agreement. That if it would we feel comfortable saying, the like this section that we're talking about is really the establishment of kind of what the rule says. And here, and I guess maybe that would be the thing, it would be either we address that here or we address this down here, that lawyer, because here's the kind of the application, I guess, so to speak. The section, this is the paragraph that starts here, lawyer executed a fee agreement. We're talking about these specific facts, and maybe instead say lawyer may, instead of attempt to renegotiate the fee agreement, may increase the fee. It can't be unilateral, it needs to be some sort of it needs to be some sort of,
Periodically
you know,
increase the
notice,
fee.
reasonable notice. That's where we start getting into the notice to the client. So maybe we don't, I guess
Lawyer
maybe,
may provide for a reasonable fee increase in their agreement with client instead of attempt to renegotiate the fee.
mm-hmm. What do you all think of that?
Maybe it would almost say if lawyer anticipates an increase in billing rates during the course of representation, lawyer may provide for a fee increase with adequate notice to the client. Or
Mm, I see what you're saying. Yeah. Instead of like it being a desired increase, almost kind of like an after the fact, it's an anticipation.
yeah, when clients hire us, it may be quick for a separation agreement, or everything may blow up and it may turn into, an 18-year custody case,
Yeah.
unfortunately. Um, and so we do have to anticipate that there may be a fee increase at some point.
I think this is what Brian said, and I'm repeating it just because I want to make sure I understood it. But it seems like comment 5 to the rule assumes that you make an agreement for a set fee with no provision for an increase. And so then when you want to do an increase, it requires a renegotiation of that fee agreement. And
Mhm.
what this whole proposed opinion is dealing with is the idea of a fee agreement that provides for adjustments to your rates and how you go about doing those. So I'm not sure comment 5 it really addresses the issue,
Mm.
particularly with regard to the idea of renegotiation, because I think that's a concern. And I think that the idea here is that we've already made it clear in the agreement, and the client has agreed that the fees may be adjusted. Now it's just about the process that you have to go through to do the adjustment, and what happens if they don't agree to the adjustment.
Right. No, I think that's a fair view, John. That maybe comment 5 isn't as restrictive, or at least it's not as it doesn't characterize this situation
That's right.
like, as appropriately. Okay. Well, I'm thinking like this is I've got a couple of thoughts. I know we've hit 1 hour, so I don't want to keep us. And Davis has a jury to pick in 2 hours. But it's also I've got some thoughts swimming in my head of how we can better capture this sentiment that I know John and Lori have been you all have been contributing here. Davis and Elizabeth, I don't know if you have any different thoughts. Otherwise, I'm kind of going with what John and Lori, the direction that John and Lori are giving me.
I do not. I think it's great input, and I don't have the real world experience that they have in dealing with these types of matters. I haven't ever increased my rates before.
Yeah. Okay. Well, then if y'all will let me then, let me see if I can capture this thought here and shift away from this renegotiation term. Um, and uh, and even to and I think maybe that's the thing, John, to what you just said. There's a way to recognize what the rule says and distinguish it from this
Mhm.
scenario.
Right.
Like you said, it's it's now about the process of what is how you go about that. The client has agreed to some sort of increase, but how you go about that needs to also be reasonable under our professional obligations. So, um, okay, let me take another crack at this and send you a copy. I know we've got the January meeting coming up in 2 weeks. We're going to be posting the agenda deadline or agenda deadline, the agenda this Friday. So I want to see if I can kind of capture some of these thoughts and send them to you this week. If I have captured them adequately, such that you all feel like, yep, that's what we talked about, and I'm ready to vote on whether this should be republished or whatever, then feel free to respond only to me. Don't do the reply all thing for fear of creating an open meetings act issue. But I can collect that information. But otherwise, if we want to have another meeting, we could potentially have one, and because I think it'd be great to get this thing out in the new year. We could have another one, after our agenda goes out on Friday. That would be absolutely fine. And we can tackle this. We can add it to an addendum or what have you. But let me take that first step of seeing if I can capture what we talked about today.
Okay.
Thank you so much.
And
I think that sounds great.
Brian, as I mentioned, I'm still going to be in this trial in 3 weeks. So if someone could, I think that I saw Gina was the vice chair, so obviously she can lead the meeting, I think. And then if we could just assign maybe a volunteer to comment after you on this subcommittee for our recommendations and conversation.
Yeah, I think that'd be great. I think Lori was ready to step in. And
I think I'm gonna add
in
somewhere
case
along the way.
so yeah, we'll work that out. But yeah, I'll send this over to y'all. I will hope to get you all some edits in the next day or so, and we'll just kind of keep running from there.
Thank you.
Sounds good.
Great.
Wonderful.
Thanks, everyone.
Thanks, y'all. Good luck today, Davis.
Yeah,
Appreciate
good luck.
it.
Good luck.
No, good luck.
Thank y'all. Thank y'all.
Break a leg.
All right.
Appreciate it. Y'all take
All right.
care.